Welcome back to Give Me Credit. I'm J.S. Waldo, author of Mortgage Lending Explained, and we are here today with our credit genius guru, John Mackey, our beautiful host. Hello, John.
How are you, JS?
I'm good. John is the author of Credit Genius. You can find us on Substack. John is at creditgenius.substack.com, and I'm at jswaldo.substack.com. You can find Give Me Credit on practically any platform that you listen to for your podcasts. We are specifically on Spotify and Apple Podcasts, YouTube, like I said, many more. Please, if you're listening, like, subscribe, ring that bell. You know the drill. It helps us more than you know. And also, if you have any questions or comments, please throw those in. We answer every last one of them ourselves personally. So today on Give Me Credit, John, I'm going to turn this over to you. Take it away.
Excellent. Well, joining us again is attorney David Cox. You can see his bright, beautiful face there. In his first appearance, David helped us separate legal myths from legal realities. Today, we're tackling another misunderstood subject, and it's called judgments. Many people believe that once a creditor gets a judgment, the money automatically follows. The reality is very different. It's more complicated. We'll discuss what a judgment actually does, the challenges creditors face when trying to collect, and why many cases ultimately become a business negotiation rather than legal battles. Welcome back, David.
Thanks, John. Good to see you again. You too, JS.
Yeah.
Hey, you too, David. And I'm sorry, I neglected to mention, David, you are with Two Rivers Law. So again, this is David Cox with Two Rivers Law.
Okay. David, many people believe a judgment means the creditor automatically gets paid. How far is that from reality?
That is definitely not a reality.
Okay. Can you expand on that a little bit?
Sure. Look, so I guess maybe we'll start at the top. What is a judgment, right? And what does that allow you to, or what does that allow you to do? A judgment is a determination by a court that money is owed, and it's an order by the court that it be paid. You can get a judgment in district court, which is the kind of court you see on TV, or you can get it in what's called conciliation court, also known as small claims court, which is an expedited form of litigation, much faster, much cheaper, and you could do that if the amount is less than a certain amount owed is less than a certain amount. It's $20,000 in Minnesota. And I think most consumer credit matters probably get resolved in or sued out in conciliation court.
Right.
Yeah.
Right.
And so once you have a judgment, now you have the power of the court behind you to ask the sheriff to seize money and assets. But seizing money and assets is a lot easier said than done.
And
So
that's what we're going to talk about today. Yeah.
Yeah. So are we talking about a civil judgment here, David?
Yes.
Okay.
Yes.
So what powers does it give a creditor that they didn't have before obtaining it?
Well, lots of ways to explain that, but like I said, it gives you the right to the power of the court behind you to seize money and assets. You can get basically what's called a writ of execution. Once you have a judgment, you can get what's called a writ of execution from the court, which you then provide to the sheriff, and that's basically an order of the court directing the sheriff to go and seize specific assets. Okay, and you didn't have, before you had your judgment, you couldn't do that. I mean, sure, you've got a contract, you've got an invoice, and all that, and that's great. But now that you have a judgment, now you can get court documents directing the sheriff to go and do something about it.
Okay. What are some of the biggest obstacles creditors encounter? Now, in our discussion, the consumer could be the creditor or not. It could be if you're suing or if you're being sued. So what kind of the creditors, the encounter after they win a judgment? What are some of the biggest obstacles of that?
Collecting on it. And I think, I would say that obtaining a judgment is a lot easier than collecting on one.
Yeah.
I mean, extracting money from somebody who doesn't want to pay you is a lot harder than people think, especially if they don't have the money. As we've said, or maybe we haven't said it yet, but getting a judgment does not mean that you get paid. You already have a piece of paper that says this person owes you money. Now you just got a new piece of paper that says they owe you money. It's not the same thing as actually getting the money. So, again, we were talking about the writ of execution. Okay, now you've got your writ of execution to go after a person's assets, but finding those assets, or sometimes finding the person, can present challenges. And even if you know where the assets are, the time and the paperwork required to get them can be burdensome. And something that people don't think about. Unless the asset that you're extracting from this debtor is cash, if it's a thing, especially a big thing, like a car or something, now you have to store it and sell it, which costs more money. So let's say you're able to have the sheriff, you get a judgment against somebody and they own a classic car and where it is and what it is and all that. You have, specific information for the sheriff and they go out and seize it. Well, now you're going to have to store that thing somewhere. You can't just list it for sale on Auto Trader either. You don't have title to give to the buyer. So now you're selling it at a sheriff's sale where it goes for less than it's worth. Then the sheriff takes their cut. It takes a lot of time. In summary, collecting on a judgment can be harder than people think. Yep.
Which you just answered my next question. So thank you.
Yeah. So we'll go right back to me then.
Yeah.
What assets are commonly available to satisfy a judgment, and what assets are frequently protected by law?
Sure. Well, the lowest hanging fruit is the debtor's bank account. I mean, if you know where the debtor banks, and especially if you have an account number, you can serve the bank with a copy of the writ and a whole lot of other paperwork you have to draft up to go with it in order to freeze the account to the extent of the debt or the whole account if the balance isn't enough to satisfy the debt. And then you pay the sheriff to actually physically go to the bank and, quote, levy the funds, which is just a fancy way of saying, go get them, right?
Right.
Or if you have an attorney do it and it's under a certain amount, the attorney can levy the funds directly from the bank. But of course, now you're paying an attorney's fees to do that, and that gets expensive.
Yeah. A lot of you are worth that fee. Some of you aren't.
I am, right? But
yeah,
it's not cheap. It's not cheap. Maybe I'm worth it, but is it worth it to pay me to do it? Is it the question?
That's a great point.
We'll be getting to that, I think, in a bit here.
Yeah.
But, with respect to, assets that are sort of gettable, the other low hanging fruit is a person's paycheck. I mean, if you know where the debtor works, you can serve the writ and a whole bunch of other paperwork you've got to do on the employer to garnish their paycheck. Mm-hmm. But there's a lot of exceptions as to what can be garnished out of a person's check. I mean, you can't take all of it. You have to leave a certain minimum amount, et cetera.
It also depends on which state you're in. A lot of states don't even allow that.
Right. Mm-hmm. You may not even be able to do it at all. And even if you can, there could be other creditors in front of you, like, for instance, the county collecting child support.
Great point.
Yeah. Or they may not, or bottom line, they may not just they may not make that much money. I have on several occasions done all the work to garnish a paycheck and waited for weeks for it to come back just to get a check for $43 because that's all that could be legally withheld.
Yeah.
Yeah.
I don't know about these other states, but I think the state of Minnesota, and you can correct me if I'm wrong, it's they can take up to 25% of your paycheck.
Mm-hmm. Yep.
Is that gross or net?
That's a good question. And to be honest, I don't remember the answer to that. I haven't done it in quite a while.
Okay.
Yeah.
I can't remember if it's gross or net. I would My
I actually don't think it's gross because again, like you said, child support, things like that, they come first.
right, right.
Mhm.
Okay.
So
Okay.
yeah. So what else?
So,
Go ahead.
so why do you think, no, you mentioned, going back to the last question, you mentioned like if it's an auto, I mean, they can pull up and take that vehicle, but at the same time, there's so many expenses involved with, repossession of any kind, whether it's a repossession of an auto, repossession of any goods that had secured that loan, including furnishings or a house or something like that. It's quite expensive to do that. So, but
Mhm.
why do you think some judgments sit unpaid for years or even decades despite being legally enforceable?
Well, for the very reasons we've been discussing, it's often just too much work and too
Mhm.
much, upfront expense for too little of a reward. Um, and so what ends up happening is often creditors will just sell the debt to a collection agency for a fraction of the total amount owed. Because at
Mhm.
least then they get something, and the collection agency can deal with the headache of going to court for a judgment and trying to collect if they want to do that. Or, what they do, or maybe the collection agency does, is they go to conciliation court, they get their judgment, they docket it and let it sit. By the way, docketing a judgment, it means registering it with the district court. If you get a conciliation court judgment, you have to make it sort of official in district court, and it's not fully enforceable until you do that work and pay the court some more money. Um, and so once you've done that, you just let the judgment sit out there. And the hope is that someday the debtor will want to make some financial move, like sell or buy a house or refinance a mortgage or maybe buy a vehicle. And then the judgment will be there waiting for them. Um, for example, if a judgment is docketed in the county where you own real estate and you go to sell or refinance, the title company is going to find that judgment and they're legally bound to satisfy it. Or maybe you're buying a house or a vehicle and the judgment is wrecking your credit and you need to take care of it so that you can qualify for a loan. I've actually had judgment debtors call me out of the blue years later wanting to settle it because they wanted to make some move like that. And so, again, I think a lot of times creditors just say, look, it's just not worth the time and money. I'll just bide my time because one of these days the debtor's going to need to do something.
Mhm.
Okay. When creditors evaluate collection options, how many or how much of the decision is legal and how much is simply a business economics?
Um, well, if the creditor is my client asking me, I'll tell them they have to make a business decision. I mean, how much do
Right.
you realistically think this guy has that you can get, and how much are you going to pay me to find out what you'll actually get? Um, and that goes not just for collections, but for the question of whether to start a lawsuit in the first place. And this is especially true in cases where you have an amount in controversy, like say $30,000, right? It's too much to sue for in conciliation court unless you want
Right.
to write, right? I mean, you can do it, but you have to write $10,000 off the top, right, to get into the jurisdictional limit, at least here in Minnesota. Um, and then you're going to pay me, let's say $350 an hour to sue this guy in district court. You're looking at some thousands of dollars in fees. And then even if even if the debtor doesn't defend and you get a default, that's still thousands of dollars, and it's going to be potentially a lot more if there's a genuine dispute to be had, or they do the work at least to delay you. And then even if you win, now we're back to you have to collect. And again, you already had a piece of paper that says this guy owed you money. Now you've got a better one, but it's still just a piece of paper saying he owes you money. You don't actually have the money, and you have to decide, it's a business decision, is it
Right.
worth it
Right.
to go after this?
So is that why some creditors are willing to negotiate after obtaining a judgment?
Absolutely. It's that business decision.
Mhm.
And I hate to say it to clients when they consult with me and somebody owes them money, and I tell them what I just told you. And, sometimes they think I'm being a wimp or not sufficiently aggressive. But I mean, you think about it. You see, client comes in, says, this guy owes me $50,000. Meanwhile, he's got some beef. He says he shouldn't have to pay you for whatever reason. And it's, maybe his reasons are, total BS, but he's not willing to pay, right?
Mhm.
And, either we don't know, or maybe we do know he doesn't have any, non-homesteaded real estate. We don't know for sure what he's got to pay a judgment. And so then this guy says, well, look, I'll compromise. I'll pay you $30,000, right? And I mean, your first reaction is probably like, no way, you're ripping me off. You owe me 50. Why should I take 30? But, reality is you'd better at least consider it. The question might be, would you rather have $30,000 today for certain right now, or would you rather pay me thousands of dollars today to go sue the guy? And again, if there's a genuine dispute, it could be, many thousands of dollars, and it could take months or even a year to get to the end, then
Yeah.
get your judgment, pay me more money to chase this guy down and find out what you're going to get, or would you rather just have the $30,000 today?
Right.
You got to make a business decision.
Yeah, absolutely.
Yeah.
What leverage, if any, does the debtor still have after losing in court and having a judgment entered against them?
Well, it's I call it the time value of the money and the cost and uncertainty of collection, like we've been talking about.
Right.
If the debtor, if let's say there's a debt for $6,000, and the debtor goes to the creditor and says, look, I'll give you $3,000. I'll do it right now. That gives the debtor has that leverage to say, look, you can try to collect from me. Maybe you get your money, maybe you don't. But if you want to settle it, I'll give you $3,000 right now.
Right.
So at the end of the day, is a debt collection more of a legal process or a business negotiation?
I guess, well, it can be both, if there's lawyers involved, but it's a, like we said, it's a business decision. It's a negotiation.
Negotiation. Yeah, that's how it sounds.
Yeah. There's so many variables in this, and unfortunately, we've only got like 30 minutes to present in the general questions about this process to get people thinking about what could happen, what does happen. It's very interesting here.
Yeah, and also for consumers to think about, face the debt, as we're always saying, don't bury your head. These are good reasons to really face it.
Yeah. Well, so now you've answered all of our questions, David, but I'd like to throw out a real world scenario that's unfolding right now. I have a friend who is being sued over a store credit card debt. The debt was never sold to a collection agency. Instead, the original creditor is pursuing the lawsuit directly through a law firm here in the Twin Cities. And no, you're not it, David.
Okay.
Before the lawsuit was filed, she actually reached out to the creditor herself. So she's been in constant communication with them over the past couple of years. And she explained that she had experienced significant medical issues, and she continues to do so. She'd lost income and was struggling financially. She was a single mother of 3 children with 1 child still living at home. She also owns her own home that was deeded to her by her ex-husband. Now, within the next couple of days, she's got a court appearance via Zoom. I don't like that, but nonetheless, that's where it's at. My initial advice was simple: request all the documentation, including account record statements, charge payments, and anything else they intend to rely on. Beyond that, I know, you and I could spend hours discussing legal strategy, but that's not where I'm going with this question. Instead, if she were sitting across from you today, how would you advise her? What options should she be considering? And what practical steps would you recommend she take before that court appearance?
All right. Well, I mean, a threshold question here is, what is this court appearance? is if it's a conciliation court hearing.
Yes.
It is. Okay. So, it may be, well, I was going to say it may be a little bit late for her to request all that documentation. And also one of the upsides and downsides of conciliation court is, it's really fast, it's really cheap, it's inexpensive, it's relatively informal, whether she could have even gotten that documentation ahead of time or not is questionable anyway. But what I would tell her is, look, if this creditor is going to sue you, they're going to, just like anything else, they're going to have to prove up the fact that you owe them the money. And so they should be serving you and filing with the court, exhibits, right? The credit agreement, the invoices, things like that. And you should have an opportunity to review those things, before.
Which is the reason why I don't like Zoom, is because how do you review those in a Zoom meeting?
Well, they should, there's what should happen, and then there's what actually happens in real life. But what should happen is the creditor should, electronically serve her with copies of these documents ahead of the hearing. Now, they might not do it for, it might only be a day or two before the hearing, but that's what should happen, right? So, hopefully she will get a chance to see this stuff ahead of time. I think she could probably call. She could, call this law firm and ask them, would you give me your exhibits? Can you give me the documents that prove up the existence of this debt?
Right.
And I would hope that they would provide them to her, because, lawyers and creditors, they just, creditors just want to get their money and lawyers just want to get it settled. We don't want to go to court if we don't have to and spend our time and efforts on that. We'd rather just,
right.
Your information. Like, why don't let's start talking? And that's really the advice I would give her is, the same advice I was just giving about the guy that owes, is owed $50,000 or the person that is owed $6,000. Like,
right.
Call him up, tell him, she should tell the attorneys those things, right?
Right.
About her, the fact that she's got medical issues, 3 kids, single mother,
And they knew all this, David. That's the point, is that she's
right.
been in contact with them.
Right. Well, and then that's step 1. And then step 2 is make an offer. Right.
Yeah.
Yeah.
And that's exactly what I suggested. Because when I've gone to court with clients through conciliation court, when we actually appeared, typically what they will do is send them the plaintiff and the defendant out into the court. Or a judge will say, see if you can negotiate this out. And a lot of it is taken care of without a judgment at that point. Over Zoom, how can you do that? You can't.
No, you can't. You can't. Absolutely, you can't. First of all, she could try to get in front of it, and right. talk to this lawyer, ahead of time. But yeah, absolutely. You are right. In any conciliation court hearing, the first thing the judge says is, "Hey, you guys want to talk about it? Right? Go out in the hallway and talk about it." And so they create a separate breakout room,
right,
and send you there, and then and it's sort of a virtual hallway to go have your conversation in.
Yeah.
Now this is a credit card, though, correct?
It is.
Yeah. So let me ask you a question. A credit card is not a secured loan. Obviously, it's not a secured credit card, which is why they're collecting on it. Right. You mentioned homestead earlier, and I don't know if a lot of people understood that. So I'd like you, if you could, David, explain the fact that she owns a home, but it is her one and only primary residence. Is she protected under this homestead?
She is. She is. That's the good news. And I'm glad we're going here, because I had some fun things to say about this, actually.
Good.
Yeah. Your homestead, your primary residence, is exempt from collection. Now, there are limits on that. There's a value limit and an acreage limit. I think but it's pretty high. It's up to $500,000 in Minnesota, or 160 acres, and even more if it happens to be agricultural land. So yeah, this is something maybe a lot of people don't know. The creditor, they're not getting your house. They can't get
And
it.
I think that's a very scary thing for a lot of consumers. That's why I wanted you to talk
Yeah,
about it.
yeah.
Yeah,
They
yeah.
can't force foreclosure, but they could, when she either dies and it goes into the court system for
Probate.
inheritance, once they sell the house, at that point that's paid. Is there
Correct.
interest paid on a judgment that, let's say, lasts 10 years before it's paid?
Absolutely. Yeah. There's a statutory rate, and it changes based on on the sort of federal rate. But I think it's 6% on a judgment of less than is it $50,000 or $100,000? I always go back to the statute to read it. But
Sure.
yeah, absolutely. Statutory interest collects on a judgment, and if it sits out there for 10 years, that there can be a lot of interest.
Yeah, and I mean, from the mortgage side, even if she wanted to do a refinance or anything, it's going to show up on title. You mentioned that. And so then it would be forced to be paid from the proceeds of whatever in order to complete that transaction.
Right. So the creditor with a judgment against you, they can't force you to sell your house and kick you out. But one day, if you go to sell that house or you go to refinance that mortgage, that judgment will be waiting there for you, and it's got to get paid.
Right.
You can do it.
Yeah.
So again, it comes back to negotiation, a business negotiation. So it's definitely something to talk about, think about, and get ahead of if you possibly can.
Don't think with your heart, think with your head.
Exactly.
That's for sure. But
Yeah.
one thing I wanted to cover, it's, there's lots of things that are exempt from collection. It's not just your home.
Oh,
There's lots of things. For instance, and this is going to vary from state to state, but in Minnesota, the same assets that are exempt in a bankruptcy proceeding are also exempt from collection. So this includes, like we said, your home. It also includes your retirement assets up to a certain amount. And last time I checked that, it was $80,000, right? That's, that was a while ago. It might be more now, but retirement assets are protected up to a certain amount. Your primary vehicle can't be seized. Okay? As we've discussed, portions of your paycheck or other earnings can't be seized. Here's one. Even if they've got, they're garnishing or levying on your bank account, they can't get money that was received as in for child support.
good.
They can't get money that was received from public assistance based on need. That's going to be a big one too. They can't take, the tools of your trade. They can't take furniture and furnishings up to a certain amount. And they can't take all sorts of other kind of funny, interesting things like your pet or a musical instrument or your Bible and other
Well, they'd
stuff.
have to kill me to get my pet, just so
Right?
you know.
Right? You're coming through me first, man.
You better believe it. What
That's
about
right.
like something like a college savings fund for your child?
Well, nope, that they could get.
Okay.
So, and it depends on what we mean by college savings funds.
Like what are those called? They're called something. 50 something.
The 529.
Yes.
I would have to double check. I think I'd have to double check that.
Look at me stumping you.
I know you are. You got me on that one, but I know right where to look. I'm doing it right now.
Oh, awesome.
Isn't it?
It's a valid question. A lot of people set money aside. Grandparents put into that fund. That's where I'm coming from as a grandparent. Is a lot of people put money into that, not just the parent.
Yeah.
Oh, valid.
That gets bank accounts held with third parties. That's where things get really interesting. There's a whole line of statutes dealing with that. Proving up what portion of a bank account belongs to me versus what a portion of a bank account belongs to someone else for purposes of collection. All right. So I don't think a 529 is protected. Health savings accounts, like HSA, medical savings accounts can be protected up to a present value of $25,000. under
That's good.
Minnesota law right now, but I don't think your 529 is going to be.
Yeah, I say that you contact your congressman and get that passed because a 529 should not be touched. Again, a lot of people put money into that other than just the parents.
Right. Well, but if that's the basis of the objection, there are actually there's some protections for the grandparents' money.
Yeah, but I mean, but then you have to prove it, right? You go and you
Right.
prove who's
Right.
putting all that money in. I mean,
Yep.
you know,
And you're
what if
paying
the
a lawyer-
grandparent handed it to the daughter and the daughter deposited it, or you know?
Mhm. Right.
Yeah, a lot of
Right, yeah.
curves.
Yeah. Now it's lawyers in courtrooms.
Right.
So that's, it's not cheap.
David, we're going to have to cut this off, and I know that I could talk about this ad nauseum. In fact,
too.
looking at me, it creates the ad nauseum. But
Ah,
thanks for joining us again, David. I think one of the biggest takeaways from today's conversation is that judgments are often misunderstood by both sides.
mhm.
Creditors sometimes believe a judgment guarantees payment. Consumers sometimes believe a judgment means all hope is lost. The truth, as we've learned today, is that judgments create opportunities, limitations, leverage, and choices for everyone involved. More importantly, we've seen that successful outcomes often occur when people stop treating debt collection as a war and start treating it as a business problem. Think with your head, not your heart, that needs a practical solution. Thank you for sharing your experience and insight with our audience.
Yes, David, thank you very much for being with us. And thanks everybody for listening. We hope today's discussion was helpful, give you a better understanding of how judgments work, how it's entered, negotiation, all of that's important. Whether you're a consumer, a lender, a collector, or simply someone trying to understand how the system works, knowledge is always your best asset. Knowledge is power. There's that little rainbow. David, again, is from Two Rivers Law. Thank you, David, for being here.
Thanks for having me.
You can call him at 763-575-7911. Again, that's Two Rivers Law. This is David Cox that's joined us today. You also can go to the website, which is www.tworiverslawoffice. And I'm going to spell this for you, just so for those who are listening. TWO is when I say two, I'm talking TWORIVERSLAWO, F as in Frank, ICE.com. So again, if anybody needs David's assistance, that's how you contact him. David, thank you so much for coming in. We loved having you the first time. It was great having you here again. So I'm going to nail you right here to the floor. Can we count on you for our next season?
I hope so. If I know something that you think will be interesting to all those listeners out there, I'll be glad to come back.
That's awesome. That's awesome. And we do appreciate your expertise. For everybody listening, this has been Give Me Credit. Please like, subscribe, ring that bell, follow along. You all know the drill. Podcasts are everywhere. I don't have to remind you. We are actually getting to the end of our first season. Can you believe that, John? Our first season.
I really can't.
It is amazing. A full year.
It's been a lot of fun.
It has. And we will be back. We have been signed on for our second season, so we will be back. As I've stated to you before, please don't stop sending your questions, your comments. We're still here. We're still going to be working. We're gearing up our second season. We're still here writing. You can follow along for me at jswaldo.substack.com. And of course, our credit genius, John Mackey, is always available. You can find him at creditgenius.substack.com. And David, thank you again for joining us. We look forward to future conversations with you in our second season. And thank you everybody for listening, watching, wherever you're joining in, and have a great day.
David, thank you. JS, thank you. Let's now go have a martini or something.
Yay!